Welcome to the First District Court of Appeals. We have several cases on our docket this morning. Two will be argued. The first that will be argued is in Ray S.W. Ms. Steer is here on behalf of appellant. Mr. Thompson is here on behalf of appellee. Ms. Steer, of your 15 minutes, would you like to reserve any time for rebuttal?
Yes, please. Could I reserve 5 minutes?
Yes, and I will keep your time whenever you're ready to begin.
Thank you. Good morning, Your Honor, counsel. May it please the court. I really doubt that I'm even going to use the full amount of my time. This is a pretty straightforward case. SW was taken into custody on suspicion of a robbery that was reported in Avondale. He was Mirandized by Sergeant Roth and questioned about a gun and where he had thrown it. The juvenile magistrate, after a hearing in which Dr. Rothenberg testified that SW was not competent to waive his Miranda rights, suppressed those statements made to Sergeant Roth, but also suppressed statements that were later made to Officer Wormuth as Officer Wormuth was taking SW to the cruiser. The state's position is that he was not subject to interrogation, so whether he had waived his Miranda rights initially with Sergeant Roth really isn't applicable to what happened with Officer Wormuth. That statement was voluntary. All he said was, can you let those guys go? I did it. It's kind of hard to exactly hear what he said, but that's what he said. And then Officer Wormuth told him not to say anything.
Well, yeah. And so I guess you say that he was not subject to interrogation, but he was being interrogated the entire time leading up to that statement. And obviously the officer's reaction, as you just mentioned, suggested that he felt like the child should not say anything. So how do we square that with your position that it's a voluntary statement?
Well, I think that Officer Wormuth saying don't say anything, I don't think that really affects whether or not it's voluntary. What was in the officer's mind? SW was not being interrogated at the time. He had been interrogated by Sergeant Roth as he was walking to the back of the apartment building when they were looking back in the woods to see where the gun was. And then it's clear there's virtually no words spoken to him by Officer Wormuth. The extent of the conversation between them is SW asking what's going to happen to the stuff that's in his pockets. Officer Wormuth tells him that it has to stay with him. And then he asked SW if this was a good address for him at this apartment building, to which SW said no. There was no interrogation.
Ms. Steer, let me ask you, what effect, if any, do you think the on-scene identification of SW had?
I don't think that has any impact on whether his statement was just a volunteered statement, not made during interrogation. He was walked down the street. And I think that the victim identified him, and Officer Wormuth said into his radio, confirmed, but I'm not even sure that SW knew what was happening. He was just being walked down the street to the police cruiser and paused for a second.
Well, I guess that's the other point. Like, based on the expert's testimony and the conclusions by the magistrate that you don't challenge on appeal, I mean, he was a very low functioning child with like a 4 or 5 year old kind of comprehension level. And when the Miranda rights were read in like 18 seconds, how do we expect someone like that to understand and internalize the significance of, the Miranda rights?
Well, I don't think that that's what we're doing, because we are not challenging the suppression of those statements that were made as a result of him being Mirandized. I think if you look at this another way, say, for instance, Sergeant Roth had shown up. I think it was 3 boys, they were upstairs in this apartment building. If right when he walked up, before he Mirandized SW, if SW said, you can let those guys go, I did it. If he said that, we wouldn't even be talking about this, I don't think, because it would be clear that that's a volunteered statement that wasn't as a result of interrogation.
but can a child, a 13-year-old who has the mental functioning capacity of a 4 or 5 year old, can they voluntarily make a statement like that is binding on them?
I think that then we're getting into his competency to make statements. I don't think there's any question that he made this, that he can make a statement. I think it's whether or not he understands that the whole point of Miranda is whether or not a defendant understands that he's voluntarily waiving his rights not to answer questions when interrogated by police officers.
I had sort of the same question as Judge Bergeron, maybe just a different spin on it. If he's not competent to waive his rights, if he can't do that, how can he voluntarily give any statement? I know nobody's argued that, but it does seem a little contradictory.
I think maybe that would go to maybe the weight that you gave the statement that he made. I think it would go to that, but I don't think that it would be a matter of suppressing it because of him waiving his Miranda rights. Because this is I think you have to set aside the fact that Miranda doesn't apply in this case because it's a voluntary statement not made as a result of an interrogation. I think whether his statement itself, what the weight that you give that, I think maybe that's something you argue at trial, whether a 13-year-old boy can say, I did it. I think you would argue that maybe, he didn't know what he was talking about, but I don't think that that's subject to suppression because of a
well, I guess how much do we take into to account the background context? I mean, he was apprehended at gunpoint. He's been arrested. There have been a number of you're going to be in trouble if you don't tell me these things type of questions. There's people screaming in the background. There's all these police cruisers. Do we take that into account in assessing the voluntariness of the statement?
I think that when you're looking at it in terms of whether or not Miranda was violated, I think it starts and stops with whether or not he was being interrogated. And his statement was a purely volunteered statement. I think the fact that he's a 13-year-old boy with maybe below average intelligence, that's probably a question for trial, whether or not his statement should be credited. And that all feeds into it. The people screaming, he's obviously scared. Sergeant Roth was asking him repeatedly where the gun was and where he had thrown it. Obviously, that was a lot of pressure, but I don't think that makes his statement subject to suppression for a violation of Miranda.
Can I ask you one other follow-up question? In a lot of the cases, what happens is somebody is given their Miranda warnings, they choose to exercise those rights, then there's a break in time and they're in custody but not being interrogated, and they volunteer a statement. All those cases are premised on the person initially understanding that they had the right to remain silent and exercise that right for a period of time. That's what's kind of making this case a little different for me, because he didn't have that ability to, when it stopped, there is a clear demarcation of a few minutes where there was no questioning. But how do you handle those cases that I just alluded to?
Well, I think in those cases, it again comes down to whether or not it's just a spontaneous statement or whether it came as a result of an interrogation. For instance, I think, there are cases where someone's been Mirandized and then they're put back into a holding cell. If they blurt something out to, whoever the corrections officer who's walking them to the cell, I don't think that that's subject to suppression under Miranda. However, if the correction officer, as he's walking him, says, why don't you come clean? I think then that could still be considered interrogation that the defendant is responding to. And then I think you have to look and see whether or not he voluntarily waived his Miranda rights.
And you have about one more minute if you'd like to reserve 5.
I'll reserve the rest of my time unless the court has any more questions.
Any questions?
No.
Mr. Thompson, you have 15 minutes.
Good morning. May it please the court, counsel. I cannot emphasize enough what the Ohio Supreme Court said in State versus Barker, 2016 Ohio 2708, paragraph 26, that absent the state's compliance with Miranda and a suspect's valid waiver of his Fifth Amendment rights, even voluntary statements are inadmissible. This ultimately makes a lot of sense because the alternative, that someone who does not understand their rights can still make a voluntary statement, makes no sense.
So just to make sure I understand your position and kind of following up on Judge Meyer's question, are you taking, is it your position that if there is an ineffective Miranda for whatever reason, whether that's, lack of comprehension or they didn't read them the rights, that no subsequent statement, no matter how far removed from that Miranda warning, can be considered voluntary? Or is there a timeline some point in the future where it could become voluntary?
There is no timeline, but intervening events, I believe, such as perhaps interacting with a lawyer on their behalf or regaining competency and then making a statement, those would change the math, I believe.
What about like consultation with a parent for a juvenile? Would that break the chain?
It's a factor in the totality of circumstances, but I don't believe it would be a hard line that absolutely broke the chain. No, we don't have any challenge here. No question that SW could not validly waive his Fifth Amendment rights.
And let me interrupt you there. And that's because he didn't have the capability to understand them, correct?
Correct.
So going back to the questions that I think we were all asking Ms. Steer, doesn't that impact the voluntariness of his statement to begin with? And nobody is arguing that, really, are they? Nobody argued that his statement was involuntary because of his competency.
Well, I think if you cannot understand your Miranda rights, your statement is, or your admission is inherently involuntary.
So here, let me give a hypothetical. Let's say that they came upon him before anybody asked him any questions, as Ms. Steer in her hypothetical said, he volunteered, I did it. Is it your position that because ultimately he wouldn't have been competent to waive his Miranda rights, that he's not competent to make that statement and that statement's inadmissible?
The police went to him first?
Well, they're on the scene investigating. Yes, they approach him, and as they approach him, he's not, well, I guess he's not in custody. Let's say he's in custody and they haven't asked him any question yet. He's handcuffed, he can't leave. They've even maybe arrested him. They haven't read him his rights, but he volunteers a statement.
Because he's a juvenile, I still say yes, that it should be suppressed. And that's because children are due a special care. In Galt, they said the greatest care must be taken to assure that the admission was voluntary, in the sense not only that it was not coerced or suggested, but that it was not the product of ignorance of rights or an adolescent fantasy, fright, or despair. And I think that's ultimately what we have here. We know SW was only 13. He's arrested at gunpoint with two of his friends. He's got a low level of intelligence, limited prior police contact, no parent or guardian or lawyer available to him at the time. Sergeant Roth was aggressive with him, cursed at him, consistently pressured him to tell the officers the gun's location, told him he'd be in more trouble if he didn't tell him where the gun was. Also told him that if he was truthful, things would go better for him. Then ultimately, SW goes through an identification procedure where he hears he was positively ID'd. And all of that occurs before the admission. But even then, the interrogation didn't really stop. Officer Wormuth asked if SW lived at the apartment where he was arrested. He was doing a search when the admission was made and being placed in a police cruiser. And ultimately, I believe the admission was made in the interest of protecting his friends. So I think that fits right into being a product of ignorance of his, not just ignorance of his rights, but adolescent fantasy, fear, or despair. So even if we reach this totality of the circumstances question, because I don't think we need to get there under Barker and Dickerson, but if we do, then SW in particular was not a person who could make a voluntary statement.
And is that under any circumstances, no matter when in this timeline he confessed? Would your position be no, he couldn't make a voluntary statement?
If he walked into a police station and said, I need to tell everyone that I just robbed someone, I don't think that would be suppressed. I think that would be voluntary. But here where
And
there's
where are
police,
you drawing the line? I mean, is it,
the police
temporal?
interaction. Sorry, I didn't mean to interrupt.
so it's not a temporal, it's not just a time thing.
No, I believe it's a police interaction situation here, that because the police are seeking information from him, that's when we have to get into this totality of circumstances. And in this particular scenario, like the judge found, this was a continuing process. I think Miranda does apply. It's questionable whether the Miranda rights were valid, given they were given so quickly and in such a sort of desperate set of circumstances. But even if they were, clearly SW didn't understand those rights and didn't voluntarily waive them because he was incapable. And the circumstances were such that anything that he did was out of fright or despair.
Mr. Thompson, let me ask this question. We're all aware of the deficits under which SW is laboring, but from the point that he was handed off to Officer Weirmuth in the limited conversation that concerned his property, whether he lived in that building, and then his statement, can we take anything from that conversation? And I guess my point is he seemed to respond appropriately. He was concerned about the property in his pockets. The officer said, "Is that your building?" He said, "No." Can we consider that?
Well, ultimately, I don't think the state is challenging his competency, but I do think it could be considered for the fact that it is a continuing interrogation. Questions are still being asked.
I mean, a question like, "Is that your building?" Is that interrogation?
For a 13-year-old incompetent boy, I think any question is a question where the police are seeking information. It's a custodial interrogation, a custodial question. If there are no further questions, I ask that the court affirm the granting of the motion to suppress.
Any further questions from the panel?
No.
Thank you, Mr. Thompson. Ms. Steer, you have 6 minutes.
Thank you, Your Honor. Judge Winkler, if I can go back to the question you were asking, whether or not the questions regarding if this is where you live and answering his question about what's going to happen to the stuff in his pocket, those aren't those are questions. They're questions seeking information, but they're not interrogation about a crime. There's plenty of times when, police officers ask a defendant their name and other identifying information that's not an interrogation. In Miranda, the court said that it applies to there's 2 elements, custody and interrogation. In this case, there's no question that SW was in custody. He was in custody when Sergeant Roth was talking to him, and he was in custody when Weirmuth was walking him to the cruiser. But there simply is no interrogation happening. There was no questioning whether or not his statement is should be credited or given any weight, that's a question for trial. It's not a question, it's not something that's subject to suppression under Miranda. And I don't think that just because he's a juvenile, and I understand his young age, and I understand that he was low intelligence, but I don't think that there's a separate rule for juveniles as far as volunteered statements, spontaneous statements outside of Miranda. And the state submits that Miranda doesn't apply in this case. So the state would ask that the judgment be reversed as to the statements made to Officer Wormuth. Thank you.
Any other questions for Ms. Steer?
No.
Thank you both for your arguments this morning. We will take the case under submission, give you a timely written opinion.
Thank you.
And if you will bring the next parties into the courtroom, please. Good morning. The next case on our docket this morning is State versus Moss. Ms. Callaway is here on behalf of appellant. Ms. Barnett is here on behalf of appellee. Ms. Callaway, you have 15 minutes to argue this morning. Would you like to reserve any time?
Good morning. Thank you, Your Honor. I'd like to reserve 3 minutes for rebuttal, please.
All right, and whenever you're ready, I will keep your time.
Okay, thank you. May it please the court. This case is pretty straightforward, and I know the court comes prepared, having reviewed the briefs and understands the facts, and so I'm not going to rehash it unless there's questions about it. This is a pretty straightforward sentencing issue. In this case, the defendant was he was arrested for a bunch of charges, I think 11. He was sentenced for the felony to 18 months in prison. And after that sentencing took place, he went back and was sentenced on the misdemeanor charges, and the court imposed additional time that was consecutive to the felonies. And so the issue before the court, I'm not sure exactly what the municipal court judge was thinking here. There isn't a lot on the record about it. I know that prior to the Supreme Court's case in Polis, which is described in detail in my brief, there was some confusion under 292941, exactly what was being communicated with that statute. There were some provisions that some of the districts in Ohio thought were in conflict with each other, but the Polis court clarified exactly what is meant by that statute. And the upshot of it in Polis is that sentences for misdemeanors have to be run concurrent with time for felonies. And so I think this case is really important.
Does that hinge though on the defendant actually being in the midst of serving time for the felony?
No. I understand what the court is getting at, but the idea of someone serving concurrent time is a legal fiction, right? You can't actually do two things at the same time. And so when the sentences are imposed at the same time, the court must order them to be served concurrently. I understand this is a little bit of a factual discrepancy because the time was already served on the felony and then the misdemeanor charge came in for sentencing after that. But because the idea of concurrent sentences is a legal fiction, and because the statute doesn't say, well, if they're sentenced separately, that means that you can serve them consecutively. There's no exception there. We have to follow the plain language of the statute, which says that the sentences must be ordered to be served concurrently. And so it doesn't appear based on the language of the statute or the court's decision interpretation in Polis that there's an exception there for if they're sentenced separately. This case is important because of this function that we have in Hamilton County where cases can be put on the suspended docket. I think in most jurisdictions, the suspended docket doesn't exist, and it creates an opportunity for what happened here, which is very nefarious for the defendant because the defendants often aren't even aware that cases are being put on the suspended docket. When the cases come through room A, the cases get split off immediately, and the defendants sometimes, usually, aren't even aware of it. And that's what happened in this case. The defendant was concentrated on the felony. The cases were going on. The felony was being set in plea or trial settings, and the misdemeanors were just hanging out there. There was never any court dates.
And the purpose of that rule, at least as I read it, is that it is basically to give the defendant the benefit of the statute and to avoid having the courts have to deal with the misdemeanor while the felony proceedings are ongoing. Is that fair?
I agree. I'm not criticizing the rule per se, and I agree that that was the reason for the suspended docket, and it makes sense for judicial efficiency. But what happens is that I've seen this happen. I know this isn't in the record, but just anecdotally, these cases, the misdemeanors fall in the cracks, and usually.
Well, yeah. What are the safeguards here to prevent this exact scenario?
I don't know the answer to that. To be honest with you, as a practitioner, this was always a huge fear of mine, that I would forget about the misdemeanors that were on the suspended docket. I think that that's what happened in this case. The retained counsel never got word that there were misdemeanor charges here, never entered a notice of appearance, took over the felonies. The appointed counsel just figured that felony, retained counsel was taking care of everything, and then nothing was ever done. And so I would suggest that the safeguard then is 292941, which says that the misdemeanors must be run concurrently. And so the stopgap measure for having somebody serve multiple sentences like this is the plain language of the statute, which says that misdemeanor time must be run concurrent with felony sentences. And so
Ms. Callaway, let me ask this, doesn't it say served concurrently? And if he's already served his sentence for the felonies, isn't the judge free to sentence on the misdemeanors?
Well, I understand the court's question, but again, I would just point the court back to the idea of what a concurrent sentence is. A concurrent sentence is a legal fiction, and the idea that you can serve two sentences at the same time is something that we've all just decided is possible, even though I'm not sure in the laws of physics that that's an actual thing. But the courts and the legislature have all decided, like, okay, we're going to operate within this legal fiction because that's our preference, that the sentences all be served at the same time. And so I don't think that these cases that got siphoned off, either I'm going to say by accident, I'm not going to, wasn't on purpose. The state didn't do this. This was an accident. That somehow now gives this defendant, it can be penalized twice when the statute requires plainly that the sentences be ordered to be served concurrently. And so that language served concurrently, again, is a legal fiction. And there's nothing that stops the court from operating or operationalizing the legal fiction that it be served concurrently, whether the sentence or sentenced to be served on the same day, or whether the sentences happen a month apart or 2 years apart. The legal fiction is still there.
And so if I understand your argument, in this case, if he had been sentenced in felony court and then taken immediately down to municipal court for sentencing, those would have been served concurrently. And the fact that it didn't happen immediately should make no legal difference.
Correct. The court's decision in Polis, I think, is unambiguous about that. This case is a little bit factually different from Polis just because of the amount of time, but that is correct. That's my position. Whether it was an hour or 2 years, the statute says that the municipal court had to impose a concurrent sentence.
But does that argument only make sense if the claims are related? Like, in other words, in your 2-year scenario, if he picked up a misdemeanor 2 years later after being sentenced and serving time on a felony and there's no relation, like you wouldn't be taking this position in that circumstance, would you?
Well, that's not what happened in this case. These cases all arose out of the same traffic, the same incident. So these were all part of the same course of conduct. But no, even if these had been separate, I believe under Polis, that was the factual scenario in Polis, and the other case I cited from Belmont County in my brief, that happened. I think it was a probation violation got revoked and the court imposed a sentence, and then they picked up a separate charge separate from that probation violation, and the court imposed separate sentences. And on appeal, the appellate court said, no, under 292941, sentences must be served concurrently, even when they arise from separate factual incidents. So this was a probation violation and a new charge. And so that wouldn't be my position. I believe that the sentences must be served concurrently. Now, in that case, they're obviously being served at the same time. If he picked up a probation violation, served his time, then came back and picked up a new charge, no, I don't think those sentences have to be served concurrently, because they do arise from separate instances. And so
Procedurally, in this case, the municipal judge would order a sentence and then find that there's credit for all the time served. Is that procedurally what you would suggest should happen?
my suggestion would be that if the court feels that it needs to order additional time, that it order on the sentencing entry that it be served concurrently with the
But
felony
that, I
time.
think, gets to Judge Winkler's question. It's over. So concurrent to what? Wouldn't then it have to be credit for time served?
I don't think so.
Let's say the judge did say concurrent, and that gets to concurrent to what?
Yeah, it gets concurrent to the felony sentence. That was a companion case here. And so I don't think that that's any different than what they would have done if they had sentenced on the same day. Courts in their entries all the time, right? Concurrent to case number X or concurrent to case number Y. That's all the court had to do here. 60 days concurrent to, and then the case number of the felony that was a companion to this case.
I think the question that both my colleagues are getting to is that, is it possible to serve concurrently a sentence that has already been completely served? Like if you get in this scenario, if the judge has said, serve this 60 days concurrent to this felony charge, is that possible given that the felony sentence had already been served?
I understand the question. My answer to the question is yes. It's possible in the same way it's possible to serve any kind of concurrent sentence. A person is ordered to serve 12 months for a breaking and entering and 12 months for a drug possession, and those sentences are ordered to be served concurrently. They're serving them at the same time. That's a legal fiction. This, in the exact same way, the municipal court in this case should have ordered the 60 days to be served concurrent to the felony time, serving at the same time, just the same way they would have if they had ordered the sentence to be served on the same day. I understand the court's troubled over this, whether they can be served at the same time once it's already been served. But with all due respect, I feel that the court is fighting the idea of the concurrent sentence. No one can actually serve a concurrent sentence. This is a policy decision that the legislature has put forth to say, we want these sentences to be imposed concurrently. And so there is no difference in saying that this should be served concurrent to the case number. So that's my answer to that.
Ms. Calloway, I'm in substantial agreement with what you're saying here, but in the Paulus case, didn't the sentencing judge have Mr. or Mrs. Paulus in front of him at the same time that he or she sentenced the defendant concurrently?
I believe that's correct, yes.
And this is sort of an anomaly. Couldn't Judge Bender have sentenced your client to 18 months in the Department of Corrections and merely credited the time, in the Justice Center, and credited the time that he had already served? I mean, that was within her authority, wasn't it?
I think the time has to be served concurrently under the statute.
But if she credited it, if she credited the time, the effect is it was served concurrently?
Yes, we would.
Serving it.
I'm sorry, Your Honor.
That's okay. Go ahead.
Yes, we wouldn't be here. I certainly wouldn't appeal that. And so the effect would be the same. And so as long as the client isn't harmed by it, that's fine with me. I think the more proper way to do it in the entry is to say that it's being served concurrently. But if you want to effectuate the same outcome and not use that language and make it more logically consistent, then yes, that would be a way to do it as well.
Well, but my point is that sentencing judge in the municipal court could have sentenced 8 to 18 months, and your client served about 11, I believe. So wouldn't he have served the balance of that sentence over in the Justice Center? Do you understand my question? He'd
You're
serve his
saying
state
that,
sentence, and then there's a balance left, and they would transfer him back to the Justice Center to serve out the balance of his misdemeanor sentence, and they would have been served concurrently.
that is correct. Yep.
And
But
you are
the-
at your time, Ms. Callaway. I'll let you finish that answer to that question. And then if the
Yes.
panel has any other questions.
Yes, I appreciate the judge's question, and I agree that that could have been a possible outcome in this case, but that's not what happened. And so because of the way that the court imposed the sentence, it had to be served concurrently under the statute. Thank you.
Thank you. Any other questions from the panel?
No.
Ms. Barnett, you have 15 minutes.
Thank you. Good morning, Your Honors. May it please the court, opposing counsel. I would start by saying that I disagree that this case is straightforward, as all the issues that have been discussed so far, including the suspended docket. I think this case is actually rather unique for a few reasons. First and foremost, it was brought about by the use of the suspended docket, which is unique to Hamilton County. So we don't have case law from other jurisdictions about how to handle this.
And would you agree with my characterization that the suspended docket, at least it's embodied in the rule, is designed to preserve this type of essentially benefit for the defendants and preserve judicial economy? Is that fair, or would you characterize it?
Yes, absolutely. I would agree with that characterization. Practicing in municipal court, oftentimes we get cases where there are some misdemeanors and we get wind that there are felonies. So then it becomes a discussion, why don't we put this on a suspended docket, especially if they're arising out of the same incident, let's see how that plays out. And then when the felony is resolved, usually we confer with the officers, how do you want to deal with this if there's a victim involved, which is, I think, why this case played out the way it did, because officers were the victims of those misdemeanor charges that were lingering.
But then getting back to my question to Ms. Kelly, what's the safeguard to ensure that these things get wrapped up and we don't have the scenario like we have here?
Unfortunately, I don't think there is a lot of a safeguard. Usually what happens is they get a suspended docket date to come back. And a lot of times it's just trying to track with the felony. So, and unfortunately, a lot of times the defendants have different counsel on the felonies and the misdemeanors. So they're trying to communicate with the felony attorney. Okay, they have a clear trial setting in a month. Let's set this out either 2 months for a report, or they pick a suspended docket date sometime out in the future. And the suspended docket is dealt with separate from, your normal trial court attorneys, handled separately in room A. Ultimately, that's where those are usually adjudicated. So I don't think there are a lot of, unfortunately, clear systems to track these cases together.
I mean, then isn't this a case of ineffective assistance? Like if the lawyer had done what the lawyer should have done, there's no question that this would have run concurrent with the felony, and the lawyer didn't do that. And now if you're right, then that means this defendant is subject to extra time because the lawyer dropped the ball.
Sure, I have a couple of arguments to that. First, the trial court attorney did attempt to get him back to resolve these. So I think that while they weren't, and I think it was just a mere number of days between when he was given that felony sentence and when the misdemeanors were set next, and the sheriff wouldn't bring him back. So I would say that his at least attempt makes it so his actions weren't completely deficient. And my second,
but I guess I have trouble with that, because he attempted and he failed, and like the net result is that the client didn't get the benefit of the statute.
Sure. My other argument to that would be that undersigned did represent at trial. So I would just say that ineffective argument is waived. Can't argue as ineffective on appeal. But if I could get into my other arguments, I think it would kind of speak to why the defendant wasn't even prejudiced. So we wouldn't even get there.
Yeah, tell me how the defendant
Sure.
wasn't prejudiced.
Well, so if you look at the dates and everything and you really break it down, Judge Bender was actually, I think what she was doing was trying to get exactly up to that 18 months. And that's another point that's kind of important in this case is that total aggregate maximum allowed time of 18 months on misdemeanors. We never exceeded that. And I know that's not the main issue here. The issue is the concurrent versus consecutive. Mr. Moss was actually released for whatever reason 49 days early from what would have been his release date. He should have been released on September 28th, 2020. He was released August 10th, 2020. That's 49 days early. Judge Bender gave him 60 days, credit 11. So she got that 49 exactly right to get to that 18 months. But what's different from the Polis case is that kind of what you guys were all getting at earlier is that these weren't adjudicated at the same time. So there is no sentence to run it concurrently too. So,
So on that point, you and your brief say if he had served the full 18 months, that may have created a situation where the trial court could not impose any further sentence for the misdemeanor. So I'm having trouble reconciling that point with what you're arguing today, because you're seeming to connect the misdemeanor, and you just did, to the felony sentence. So like, why shouldn't we connect that as well and then give the defendant the benefit of the statute?
I would just say Polis wouldn't apply in this situation because we have the suspended docket and they weren't adjudicated at the same time. She had that time to sentence, and technically she had, more than that 18-month aggregate sentence to impose. And as Judge Winkler was saying, she could have, imposed 18 months and credited him for those 502 total days that he did. And that would have been a different question than if those had been run concurrently, there would still be that little bit of time left. And I think that those 49 days still technically could have been served in the Justice Center after serving his time in prison.
Could she have run those consecutively?
I don't think so, because then you would get past the 18-month aggregate.
Well, so that's my question though. Why is 18 months the barrier here?
The statute has just determined, the legislators determined that 18 months is the maximum you can do on misdemeanors. So I think Judge Bender was trying to craft a sentence to get to that 18 months.
No, let's say in this scenario, he had served the 16 months of his 18-month sentence on the felony and was released. Then he goes in front of Judge Bender and she sentences him to 18 months consecutive. And so he's got an entirely new 18-month sentence. Would that be permissible under your view?
I don't think so, because then we would come into that 18-month issue. I think she would have to credit him the 16 months he already did. And he
that's my question. Why would she have to credit him? Is it because they're all related to the same kind of offense, the same transaction or occurrence?
Partially, but I also just think in any circumstance where you're dealing with multiple misdemeanors, even if it was 5 misdemeanors, you still couldn't exceed that 18 months. So say someone was in the Justice Center for 3 misdemeanors, 3 M1s, and they were serving 18 months, 16 months into that sentence, say they assault 2 other inmates. I don't think that you could impose a consecutive 18-month sentence or whatever it would be past that 18 months, even though they aren't related. Do you see what I'm saying? I don't think if he's serving time on an 18-month sentence, I don't think you can tack on more. I think you're stuck with that 18 months.
I think I follow you, but I think it's just, it's confusing how this works. And I feel like the case law on here is confusing as well. And that's why we're asking you all these questions.
Sure. The final,
may I ask you a question, ma'am?
Sure.
You have to refresh my recollection on the suspended docket, but my recollection is that one ends up on the suspended docket at the request of counsel. Once placed on the suspended docket, there's an OR bond placed on those misdemeanors. Is that still the case?
Yes, we have to, the judge has to amend the bond to an OR once those were placed on the suspended docket.
Okay, thank you.
The final point I would make, and not wholly irrelevant to any, due process arguments that are made on behalf of Mr. Moss, but he is currently in violation of his parole. So if this court were to agree that these sentences need to run concurrent, it could be remanded to the trial court to run concurrent to any time he's going to ultimately serve on that parole violation. He is a violator at large right now.
Is he sort of outside the record, but is it related to the felony which he served as 12 months or 11 months, whatever it was?
Yes, Your Honor.
It's not another case.
I think it's something stemming from the parole that he's on these felonies. If there are no other questions, I will submit and ask that this court affirm the convictions. And if the court is to agree with the appellant, that the sentences be remanded to the trial court for clarification. Thank you.
Thank you, Ms. Barnett. Any other questions? Ms. Callaway, you have 3 minutes remaining.
I would ask the court to strike or not consider these things that aren't in the record. The state's information about how many days he served in the Ohio Department of Corrections is not in the record. When he was released is not in the record, and new charges aren't in the record. And so I don't think it's appropriate for the court to consider those things. I do want to clarify in the state's brief and argument today, this argument about undersigned counsel representing, and so not being allowed to raise ineffective assistance. There were two different attorneys in this case. There was a court-appointed attorney who at all times represented Mr. Moss on the misdemeanor, and then undersigned counsel who was retained on the felony. And so counsel is not arguing that he was ineffective. It's that appointed counsel was ineffective. And while ineffective assistance of counsel seems to be an argument that could carry the day here, I would still encourage the court to please make the decision on the first assignment of error so that we can clarify this for future cases, and that people aren't prejudiced because there is some kind of mistake with the suspended docket. And I would point the court to my third assignment of error. If the court thinks that what happened here was appropriate, then the suspended docket violates the fundamental notions of due process, because putting a case on the suspended docket and then allowing it to sit out there until someone has served their felony time really frustrates 292941's intent and plain language and the Supreme Court's dictates in Polis. And so I would argue that it violates the 14th Amendment, and that the suspended docket should be struck down, and that for those reasons, this sentence should be ordered to be served concurrently. And so my first assignment of error is the place I'd like the court to focus and order that this sentence should be, or the court should just order the sentence to be served concurrently. It doesn't need to be remanded. If the court doesn't feel that's appropriate, then I would ask you to please make the decision on the 14th Amendment due process argument that allowing cases to be put on the suspended docket. I mean, this is something that the state could then use to their advantage. Just get cases on the suspended docket, allow the felony cases to go forward, and then come back and impose additional time on the misdemeanors, which really violates the plain language and the spirit of 292941. Obviously, the ineffective assistance of counsel issue is there. But again, I feel for the attorney in this case, because these cases get put out there. And as state counsel for the state explained, there are oftentimes different lawyers on the misdemeanors and the felonies, which is also problematic because the felony lawyers don't know what's going on, or that there's even misdemeanor cases on the suspended docket. And it's very difficult then to make sure that these all get wrapped up together. So if there aren't any other questions, I would just ask the court to order that this misdemeanor sentence be run concurrent to the felonies.
Any other questions from the panel?
No.
Thank you, Ms. Callaway. Counsel, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. We'll conclude our oral arguments this morning for the First District Court of Appeals.